Well, thank you, Chairman Saylor and the committee. I wanted to just kind of relate that when the State Board talked about the quality goals of education when they began, and they had an assessment that they started in 1965. That was the EQA. I was the parent that filed the federal complaint against the Pennsylvania EQA. Pennsylvania was forced to withdraw the Pennsylvania EQA because they were testing attitudes, values, and opinions and beliefs. So I'm actually pretty much an expert at reading contracts from Pennsylvania. Also, with the resolution of that complaint, Pennsylvania was forced to implement a policy on the state level. It's called Basic Education Circular 8-90 that stated that Pennsylvania would never do that again. They would never test attitudes again. And I will have to say that we had found just recently that the State Board and the Department of Ed is trying to implement that again, and that's for later on in the discussion. When you were referring to your House Resolution 338 when you began, and you stated that the House would want local control, they didn't want a model curriculum, they didn't want a national standardized test, they didn't want it to be burdensome, they wanted to protect the privacy of children. I can tell you that the Pennsylvania Department of Ed is violating every one of those right now. And I think it would be really important to give an overview, just briefly, about the Common Core. And it was stated that, it was actually a memorandum or a contract that the state went into. It is the contract was accepted in 45 different states. The thing that most people do not realize is that the Common Core was actually a power shift away from the local district, more toward the state, creating a graduation requirement, which of course one would be the Keystone exams. But more importantly, what that did was also standardize the data elements also for computer retrieval. So not only were they stating that every child had to meet specific outcomes, that's a huge power shift, where before it was the local district that was creating the standard and the teacher in the classroom. So what you have is somewhat of federal encroachment by having standards that are coming down upon the states. So it's basically a huge power shift to the individual child. So now we're saying our children in Pennsylvania have to meet individual standards that someone on the federal level had created. Now, the other thing that's really important about that is that it was a contract that the state went into. They stated that you had to use 85% of those standards. You only have the availability to change 15%. That 15% is what has been going on for the last several years, changing the standards or doing whatever, or improving them. We have 85% of the national curriculum that we have accepted because of the memorandum we did. Now, the second thing that was really important that was federal encroachment was the change of the Family Education Rights and Privacy Act, which is FERPA. I got very much more involved in Pennsylvania education. I would actually do more national speaking than I do in the state, but that has changed recently. The Family Education Rights and Privacy Act was changed by an executive order by this president. Unfortunately, what happened at that time was that there were contracts now allowed to be had between our state departments of education with outside contractors. Knowing that the regulation had changed, I had a meeting, and Mr. Bannister was present at the meeting, one with a Representative Lawrence, and one with Senator Fulmer. We requested these contracts that actually allow these third-party contractors to have access to personally identifiable information on our children. Most people do not know that. It's a loophole in a new FERPA regulation. We requested those contracts from Senator Fulmer, and we do have them all. We do have the Keystone contracts, and we have actually read them all. The The second thing that it did with the FERPA regulation was that in order to create these individual standards, the federal government was implementing a data system to monitor. Pennsylvania Department of Ed has accepted over $24 million from the National Center of Education Statistics to implement this data system to collect information on individual children. However, when we look closer at the contract, it was actually a contract that was to be implemented as a national ID for every child, adult, every adolescent, every teacher, every principal, every superintendent has now a national ID. The significance of this was that the data system was to be implemented to create a womb to workplace data system. This is a huge invasion of privacy. The personally identifiable information, the definition expands beyond reading and math. It expands to voice prints, fingerprints, DNA strands, et cetera, that can be accessed by these third-party contractors without informed written parental consent. Parents do not know about it. Legislators don't know about it. These contracts are extremely important because this is violating the privacy of our children and our families. And of course, this is all on individual students. Every student was given a unique national ID. So in 2007 was the last where they had implemented and added children who were being born, and all the way into retirement. They included the information on wages from the Department of Labor. So this information is being transferred not only within the Department of Education to third-party contractors, but also to the Department of Labor and et cetera. So the third aspect that I wanted to talk about was Pennsylvania's acceptance of the ESEA flexibility waiver, which was No Child Left Behind. And one thing that I do want to comment on, and I actually love the last part of your bill, Representative Tobash, saying that you want to get rid of these, the keystones. However, on sentence 17, 18, and 19, you state, as required by No Child Left Behind with a statute or any successor statute, which meant that you actually just put federal statute into state law. And I would ask that we remove that so that we are not beholden to the federal government. I would ask that we only say that we want to get rid of the keystones. Yeah, I would be very happy about that. So talking about the waiver, and again, what Secretary Duncan had stated or had done at the time waived federal law. So you have No Child Left Behind, which was a federal statute, and he had presented waivers to every state. The contracts that we have from National Data Recognition Corps, stated specifically that we do in fact have a model curriculum, that we do our testing Common Core outright. It says that's what we're doing. And the current contract that we have is 2014. So you may say that we may have done away with Common Core, but the testing and the contracts are moving forward with Common Core specifically. The other things that happened, and it was also the standards aligned system, which is a copyrighted system of this model curriculum that the teachers must teach to because they are being evaluated on how well their children are testing. What happened with the waiver is that under Title I, which was discussed this morning, poverty guidelines were lowered. So in the past where Title I children were usually, or the poverty children were usually, you had to have 40% of free and reduced lunch in order to have a school-wide program. That meant that only certain children would have the free breakfast and free lunch and have specific instruction in reading. That has changed. The definition changed to educationally deprived, Any child who is not meeting a Common Core standard is now educationally deprived. Therefore, once they lowered that poverty guideline to 0, that was a blanket of Title I on every school district. Every school district would be mandated through federal mandates to meet the standards that were being implemented in your state, which would be Common Core. The waiver also expanded all of the academic areas into what they considered non-academic, social, emotional, and behavioral standards. This is in the affective domain. This directly is in violation of the Protection of Pupil Rights Amendment, and Pennsylvania has tried to implement these standards again. And in your packet is a packet called Interpersonal Skills Standards, which were put on the SAS portal stating that they were academic standards. They are not. This is a consumer protection. Parents have no idea what these are, but they are testing attitudes, values, dispositions of children. Now, how we moved forward with trying to tell different...
So I want you to wrap up because we're past the time that we
Yes,
kind of
I
allotted
know.
the minutes for each member. I mean,
Well,
we're behind
had,
schedule, but...
All right. Well, when we had gotten the contracts from Senator Fulmer's office, and Andrew Paris was there from the governor's office, I had presented the interpersonal skills. 2 days after I presented them, the governor had expunged the website portal of all the affective domain, which meant that they knew that they were violating federal law. So basically what I am saying that this federal encroachment, which is forcing this on our state, is most of our problem. Most of our problem. And the other part to the waiver was that the remediation that was talked about this morning, and I believe it was called the fidelity of teachers, okay? They talked, I believe Ms. Perez talked about the fidelity of teachers. The teachers are being trained specifically to teach to these standards. The diagnostic tool is just not academics. The diagnostic tool is academic and behavior. So when they talk about response to intervention, when they talk about the positive behavior intervention supports, we're talking about interventions in the area of attitudes, values, opinions, beliefs, dispositions of children that are in violation of federal law. Thank you.
Representative Tobash.
I just want to thank the panel for their testimony. We've brought it back here to just briefly touching on
I'm
the
sorry,
point of
could
the
you speak up?
legislation
I can't
today.
hear you very well.
I thank you for your testimony. I appreciate you bringing it back just briefly to the bill. I'm happy to talk about the wording in the bill that we have in front of us today. You brought up some issues right here that we got to discuss in a different forum. So for brevity, I appreciate the fact that you were here today, but we want to really focus on the task at hand, and that's 2 bills that we're considering at the hearing today. So, thank you. Thank you very much.
Okay, I think we outlined that, and we're willing to work with you on that. And we are willing to look at the wording again on your bill and try to make it a little more, because a lot of people looked at it and were a little concerned about the wording as far as actually getting rid of it as a graduation requirement. It wasn't quite clear. I don't know if you've ever looked at the Senate bill. It was a little more specific. So, okay.
Representative Rapp.
Thank you, Mr. Chairman. I just want to thank the panel for being here. I know you brought up a lot of information that's maybe sounds, out of a lot of our realm. But I do know that parents are extremely concerned, across the nation. I've seen some Facebook postings of some, tests and on different subjects and things that are being asked of our students. Certainly you have, I am really not aware, certainly as much as you are. I am certainly willing to sit down and talk with you further. But I know that the content and parents' rights are extremely important to parents across this state, whether it's the right to privacy or